we're going to go ahead and get started. So I'll call the meeting to order and request for bill introduction, Senator Peterson.
Thank you, Mr. Chairman. I'd like to introduce 21 RS 1847. It is a repeal of the sunset on the Contact Tracing Privacy Act.
Are there any questions or objections to introducing this bill? Seeing none, will be introduced. Thank you. Our first item on the agenda is we are going to discuss possible final action on Senate Bill 181, creating the Elevator Safety Act to require inspections of elevators for licensure and also for elevator installation and repair. Jason, are you online?
Yes, Mr. Chairman.
Could you give us a briefing on that, please?
Yes, Mr. Chairman, members of the committee, Senate Bill 181, you may remember, would create the Elevator Safety Act. This would establish state regulation for the construction and repair of elevators located in Kansas. The bill has licensure requirements to require the licensure of contractors, mechanics, and inspectors for elevators. This would all be done under the State Fire Marshal's office. That would be the agency regulating and issuing these licenses. And then there are requirements under the bill to obtain a permit from the State Fire Marshal to construct, erect, or alter an elevator. There is a requirement to obtain a certificate of operation for elevators that are in operation in the state. That is graduated based on whether the elevator is in existence on the effective date of this act. It comes into existence prior to the adoption of rules and regs next January 1st, or goes into existence after the adoption of those rules and regulations for the elevator. And then there's also a requirement that the State Fire Marshal maintain a registry of all elevators in operation in the state of Kansas as well. There is rule and reg authority for the State Fire Marshal to adopt standards based on national standards for the operation and maintenance of elevators. The bill would go into effect on July 1st of this year. But again, the rule and reg authority would come January 1st of 2022.
Are there any questions of Jason? Yes, Senator Falscadeau.
Thank you, Mr. Chairman. Jason, so this legislation would allow those requirements to be across the board. However, can you speak to the part that allows locals to have their say?
There is a provision in the bill currently as drafted and introduced that allows a city or county to adopt or continue to enforce requirements or standards that are more stringent than those that are implemented and enforced by the State Fire Marshal under the Elevator Safety Act. So they have to be more stringent than those proposed under state regulation. And if so, then the local municipality can continue to enforce and regulate elevators within its jurisdiction according to those local regulations.
Committee, I have an amendment. And would you pass out amendment number 1, please? Still having technical difficulty, so I think we can hear, but we can't, the visual is not there. Okay. Thank you. Jason, could you give us a briefing on the amendment number 1?
Yes, Mr. Chairman, members of the committee, balloon amendment number 1 to Senate Bill 181 would amend the definition of elevator to exclude the provisions in lines 17, 18, and 19 of the bill, which are referring to mechanisms that are used for moving materials, and would move that provision down into the exclusion portion of the definition in line 27. This would mean that the elevators regulated by the Elevator Safety Act would only apply to those that move people through an escalator, power-driven stairway, motorized walkway, or an elevator. But it has to be a device for moving people. It can't move just materials. That would be excluded under the balloon number 1.
Thank you, Jason. Is there any discussion on the amendment? I move my amendment. We have a second by Senator Longbine. All in favor? Aye. Opposed? Motion carries. So we're back on the bill. Do we have a second amendment? Senator Longbine.
Thank you, Mr. Chairman. I do have an amendment. It is balloon number 2, I believe.
Jason, could you give us an explanation on this amendment?
Yes, Mr. Chairman, members of the committee, balloon amendment number 2 to Senate Bill 181 would exclude elevators and wind turbine towers from the definition of elevator. You can see that amendment primarily on page 2 of the balloon, lines 21 and 22. You can see the text being stricken. And then back on page 1, down in line 30, you can see that wind turbine towers would be excluded from the definition of elevator, as would chain hoists and climate assists that are used in grain elevators and other agricultural processing facilities. And so these types of elevators would not be subject to the Elevator Safety Act and would not be subject to the inspection, certificate of operation requirements, et cetera, if the balloon is adopted.
Thank you, Jason. Are there any questions? Seeing none. Senator Longbine.
Thank you, Mr. Chairman. It's my understanding from talking to the wind turbine people that they do have a number of safety protocols in place. They do inspect their own elevators, and their people who work on the wind turbines are very well trained, and of course they're subject to OSHA requirements and all of that. So,
thank you. What's your wishes on the amendment?
I move the amendment.
You have a second? Motion been made and seconded. All in favor?
Aye.
Opposed? Motion carries. We're back on the bill. Just happen to have another amendment. Jason, could you give us number 3, please?
Yes, Mr. Chairman, balloon amendment number 3 makes a very simple amendment on page 4 of the bill. This is in the section that establishes the advisory board to advise the state fire marshal on rules and regulations and regulating elevators. Currently, the board would meet at least once each year. Under balloon amendment number 3. That minimum requirement would be 6 times each year that the advisory board would be required to meet. It would also be allowed to meet at any other time as necessary and called by the state fire marshal.
Thank you, Jason. Are there any questions? Seeing none, I move my amendment. Get a second. Senator Longbine, all in favor? Aye. Opposed? Same sign. Motion carries. And I think we have another amendment. Senator Peterson.
Thank you, Mr. Chairman. Yes, I have amendment number 4. We can get it distributed out. Basically, what it does is for those counties that have standards and requirements that meet or exceed those in the Act and the rules and regulations, it allows them to do concurrent regulation. Elevators that are, those cities and counties that have regulations like that are exempt from permitting, certificate of operation, and registry requirement. If the inspectors are city, county employees, it exempts them from the licensing from the state. And it also allows city and counties to concurrently license mechanics and contractors. Like in our city and county, they do have residential and other hoist and things in their inspection, so it'd be a little bit different idea.
Are there any questions on this amendment? Jason, I think that Senator Peterson did a great job. So is there any other questions? Seeing none,
Move my amendment.
go to second. Second by Senator Faust-Cadeau. All in favor?
Aye.
Motion carries. We're back on the bill. Committee, what's your wishes? Senator Longvine?
Mr. Chairman, I would move that we pass out Senate Bill 181 as amended favorably for passage.
Have a second? Second by Senator Dietrich. Any discussion? All in favor?
Aye.
Opposed? Opposed, and that motion carries. That bill is passed. Thank you very much for all the presented testimony. Thank you for your work today. We'll move on to our second, here we have a hearing on SCR 1611, Article 5 Convention to propose amendments to the limit federal power. Jason, could you give us a briefing, please?
Yes, Mr. Chairman, members of the committee, SCR 1611 is a concurrent resolution making application to the United States Congress to call a convention of the states for the purposes of proposing amendments to the U.S. Constitution. This is a power explicitly provided by Article 5 of the United States Constitution. It empowers the legislatures of the several states to apply to Congress to call such a convention, to propose amendments to the United States Constitution. And once 2/3 of the states have made such application, then Congress is to call such a convention to propose the amendments that are requested under the concurrent resolutions calling for the convention. In this case, SCR 1611, those amendments are to impose fiscal restraints on the federal government, to limit the power and jurisdiction of the federal government, and to limit the terms of office of its officials and members of Congress. So the concurrent resolution, if it is adopted by the Senate and the House in Kansas, then it would be submitted to Congress and would join the resolutions of other states making the same application. I will note that such a concurrent resolution to be adopted in Kansas under the current rules of the House and Senate needs a 2/3 majority vote by the full bodies.
Any questions of Jason? Seeing none. Thank you very much, Jason. Our first proponent is Mr. Mark Meckler with the Convention of States. And Mark, I understand that the next two proponents have yielded a little bit of their time to you. So you'll have a little bit more than normal to explain the Convention of States. So Mark, welcome to the committee.
Thank you, Mr. Chairman, honorable members of the committee. I appreciate your time today. And I come to you at a moment of crisis in American history. It's not a today crisis, but it is certainly a crisis that has reached peak levels in modern American history. It's a crisis that is not a crisis limited to this administration. It is a crisis of the previous administration and administrations before it. It is a crisis of a federal government that has grown far, far out of control, far outside the bounds of the Constitution as set by the founders. The founders set forth very strict limits for our federal government, and we refer to them often, as did the founders, as enumerated powers. They were limited, they were very specific. And yet, over the last 115 years approximately, mostly via Supreme Court decisions, the federal government has greatly expanded its powers to where the states have become almost mere appendages of the federal government. In this state and virtually every state across the country, it is about 60 to 65% of the budget of the state is controlled by the federal government in some way or another. And we've seen this again across administrations. The federal debt continues to spiral out of control. We just passed a $1.9 trillion spending bill. I'd posit a guess, and certainly I can speak for myself, that nobody in this room actually understands what $1 trillion is, what this does to our economy, what it does to our children, our grandchildren, and posterity. In fact, the founders told us imposing debt on future generations was immoral, and they were strongly opposed to it. They did it during the American Revolution, and they required that we pay it off as early as possible so as to not burden future generations with our debt. Today, our national debt stands at almost $29 trillion. This is an incredible number beyond comprehension, and we are burdening our future generations with this, our kids, our grandkids, and our posterity, and we must do something about this. Today, the American public, when polled, and polled consistently over the last 30 years, favors term limits for the United States Congress. The United States Congress will never impose term limits upon itself. They have the power to do so, to propose such an amendment. They've never done it, and they will never do it. It is against human nature. Today, roughly 80 to 85%, and this has been consistently polled for 30 years, favor some form of balanced budget amendment on the federal government. Most of the states are required to balance their budgets. The federal government is not, and this is the reason for $29 trillion in debt. And yet, the federal government will never impose a balanced budget amendment upon itself. Again, contrary to human nature, to limit your own power. Finally, today, 72% of the American public across the country, so that's a bipartisan number, say the federal government is too big and it does too many things. It's too disconnected from the American people. We may argue on a partisan basis about what should be done, what should the federal government do, what should it not do, how much money should be spent on one thing or another, but where we do not disagree as American people is we do not disagree on the idea that the federal government should do less and that those responsibilities should fall on the states. At the founding, there was a great debate between Hamilton and Jefferson, and most people are aware of this debate. Hamilton, the big government guy, Jefferson, the small government agrarian guy, and they argued about what was the proper size and scope of the government. Both of those founding fathers would be considered small government people today, and they did agree on one fundamental premise. They agreed in what they called exclusive spheres of authority, and that meant that it would be untenable, outrageous, uninhabitable for a country to possess two layers of legislative authority on the same subject. They actually believed that if the federal government could do something, had the power to do something under the Constitution, then states did not, and vice versa. They believed that if it was in the purview of a state, then the federal government should have no authority. Today, we have a multi-layered system. You have your own departments of energy and agriculture and protecting your environment. And the federal government has these things, making it impossible for the average person to navigate this quagmire of rules and regulations and laws. The question is, what do we do? We live in a very contentious time in American history. Seems like every issue is 50-50. Americans agree on almost nothing. Whoever ends up in charge of the houses and the presidency in Washington, D.C., 50% of the country approximately opposes, and vice versa. So what do we do about that? What is the cause and what do we do? I would argue, and I think this is borne out by circumstances, that the cause, the actual very cause of our strife in this country today is not politics per se, it's power. It's about a fundamental question. See, we argue about what Washington, D.C. should or should not do. What should be the policy on energy? What should be the policy on abortion? What should be the policy on education in our schools? And they love that argument in Washington, D.C. They all love it, both parties. And the reason they love it is because the underlying premise of that argument is that we should look to Washington, D.C. to tell us how to live our lives. The American people don't buy that premise. People in Kansas don't buy that premise. We've polled this nationally. Fully 2/3 of Americans nationally, this is on a state-by-state basis, say that it is time to call a convention of states and bring the power back to the states. And that's what we're asking you to do today. This particular resolution that we're asking you to vote on has 3 subject matter areas. It says that the convention may debate, 1, anything that imposes fiscal restraints on the federal government. That would include a balanced budget amendment. It would include maybe caps on taxation and spending. My favorite, it would include potentially imposing generally accepted accounting principles on the federal government. Most people don't realize this. Actually, the federal government uses No accounting principles. I've sat with officials at the Congressional Budget Office. They have no principles. They just decide how they want to account for things. So we need generally accepted accounting principles imposed. Number two, it could discuss anything that would impose term limits on federal officials. Notice I didn't say Congress, I said federal officials, because the problem is broader. We all understand the problem nowadays of the deep state of bureaucrats who are unaccountable, unelected. And again, this is nonpartisan. These are people who get into positions of authority, who are making the rules and the regulations. They're serving as rulemaker, as judge and jury on the prosecution of regulations, and they're not accountable to the American people. They are not elected. So we can put term limits on Congress. Yes, 80 to 85% of Americans believe we should do that, but also on the bureaucrats, on staffers, and also on the judiciary. And I think all of those things are important. The third thing is anything that would impose scope, jurisdiction, or power restrictions on the federal government. This is where we get into enumerated powers. This is where we're trying to bring the power back to the states, the power back to Kansans. Kansans elect you because they trust you and they believe in you, regardless of your party. Polling shows overwhelmingly that state legislatures have favorable opinion ratings among their constituents, while Congress, they're kind of below coronavirus in their favorability ratings. It's absolutely incredible. So your constituents want you to have the power, and the founders gave you that power. They gave you an incredibly unique power. And when I say they gave you, I mean you in particular, you as state legislatures. They gave you the power to call a convention, to propose amendments, and to ratify those amendments. That actually makes you the most powerful people in the federal government. You don't learn this when you take office and you come and you get your orientation. They show you where the restrooms are, the cafeteria, maybe the legislative drafting office, the speaker's office. They don't tell you about your role in the federal government, that you have this unique power. And there's a reason they gave you that power. They gave you that power because you are them. You sit in the same seats the founders sat in. Most of them sat in colonial legislatures, in early state legislatures, under the Articles of Confederation. They sat on county boards and county councils. And it's not that they thought that people who sat in those bodies would be better human beings. They understood human nature. It's that they understood that you would actually live among your constituents, that you would be close to your constituents, and thus more accountable to your constituents. Coming into a legislature like this, as I do every single week, reminds me of that I can walk into your office and I can sit down with you, that I see your constituents in your offices with you, meeting with you, that they talk about meeting with you out in the field. That's not true for congressmen and women. It's not true for United States senators. They have unique access to you, and this is what the founders understood, and this is why they gave you the power. I want to address one thing with all due respect about the two-thirds rules here in Kansas. I will tell you, generally speaking, they are unconstitutional. And the courts have ruled on this multiple times. You will hear otherwise from opponents of using Article 5. But this is the #1 treatise on the law of Article 5 written by Professor Rob Natelson. And so I want to read just a couple of quotations from this book. On page 38, it says, at the state level, legislatures and electorates have often adopted state constitutional rules, legislation, and interstate compacts to manipulate the amendment procedure. Yet in a long line of cases, the courts have rejected those efforts. They are unconstitutional. By the way, the list of cases takes up half a page. It starts in 1813 is the first one, and it goes all the way to 1984 cases. So this is established law and authority. Note, this principle, ordinary legislation may not alter the amendment process. That applies at every step of the process: state legislative, application, ratification, proposal, and mode of ratification. This has been recently litigated in Missouri under Calzone versus Richard. And actually in this book, the Kansas Constitution is mentioned. It says, it follows, and this is on page 39, in the Kansas Constitution, Article 2, Section 13, requiring a two-thirds vote of each entire House to apply or ratify, it's not enforceable. And the Kansas Attorney General so ruled in an opinion, Kansas Attorney General 1910 on December 4th, 2019. You have the authority, by simple majority, to pass this resolution, to join the 15 states that have already done so. There are 49 states that have filed the application. 30 states have passed it out of committee. 23 states out of one house or another. 15 states completely. This year, expect passage in between 5 and 10 states. We are going to have a convention of states, and we are going to limit the scope, power, and jurisdiction of the federal government, and we are going to return it to you. The question that Kansans are going to be asking, and there are over 30,000 of them that have signed the petition here in Kansas, they're going to be asking, will Kansas stand and make its voice heard? Will the Kansas legislature represent the people of Kansas in saying, enough is enough with the federal government, we want to restrain their power, and we want you, the Kansas legislature, to have that power? Thank you, Mr. Chairman. Members of the committee, I'd be happy to take questions if there are any.
Thank you very much. If we would, I'd like to have the other two conferees, and then we'll just ask questions of all conferees at that time. So the next conferee is David Snyder.
Good morning, Mr. Chairman, members of the committee. Again, my name is David Snyder. I work as a lobbyist for Convention of States Action from Manhattan, Kansas. I do this in several states. You have my written testimony. I won't take any more of time today, but I wanted to make sure that you guys knew I was a proponent for this very worthy cause and something I've been working on for about 8 years in the state of Kansas, first as a volunteer and now as a staff member for the organization. So thank you.
Thank you very much. Mr. David Copeland. Welcome, David.
Mr. Chairman and members of the committee, I also will be very brief, but I do stand here with behind me the 30,000 petition signers in the state of Kansas. I represent them. I am a volunteer. I've been doing this for about 6 years. They call me the state director. I manage the database, and so I know those 30,000 are out there, and I stand here for them. Thank you.
Thank you. Now, questions? Senator Hildebrand.
Mr. Chairman, I do have a few questions if you will allow, but Mark Meckler could probably answer all of my questions.
Senator?
Thank you, Mark. Thank you for your testimony. Reading through your written testimony, you said all this comes courtesy of an activist Supreme Court, which has vastly expanded federal power through its precedents. The court has created loopholes to the Constitution's limits on federal powers, and those loopholes will remain there until someone closes them. Looking at the Convention of States, nowhere in that is there a proposed amendment for judicial reform or to close that loophole on Supreme Court. If what you're saying, that is the catalyst of all of our problems, that would seem to be one of the very first, very most important things that we look at. Why do you not look at that?
With all due respect, Senator Hildebrand, it is contained in the Convention of States application. In other words, the Convention of States application, the broadest line of it is to reduce or to address the scope, power, and jurisdiction of the federal government. Of course, the Supreme Court is the Supreme Court of the judiciary branch of the federal government and therefore is subject to limitation under that clause of our application. To give you some specific examples of that, one of the largest loopholes created by the United States Supreme Court is the interpretation of the Commerce Clause. The Commerce Clause was intended to grant a very narrow authority to the federal government to regulate shipping of goods across state lines. Today, the Commerce Clause, based on Supreme Court interpretation, has given authority for the Department of Education, Energy, Commerce, the EPA, the USDA, the FDA, and an alphabet soup of agencies. All of those loopholes, that loophole, the Commerce Clause loophole, can and I would argue should be addressed in a Convention of States to limit the scope, power, and jurisdiction of the federal government, and the Convention would have full authority to do so. In addition, the Convention would have full authority, should it choose to do so, to propose amendments to specifically not just limit the court's authority over those areas or overturn the court in those areas, but to actually do away with those institutions and to prohibit the federal government from dealing in those areas should a convention choose to make those suggestions to the states and put those out for ratification. So absolutely, all these areas where the court has created loopholes can and should be addressed by a convention of states.
Thank you. I'm not sure I disagree completely with that vague interpretation, because until you address exactly the Supreme Court, they can still make those rulings, activist rulings, and you can go back all the way to Marbury versus Madison, and that's where it all begins. My second question is, you said 60 to 65% of state budgets are federal dollars. If the federal government is indeed the main problem, don't you think states should be held accountable and hold the federal government accountable? But whenever we are using 65% of that, our budget as federal dollars, wouldn't states be considered enablers to a runaway federal government?
Yeah, and I want to clarify, I did not say that the states, that 60 to 65% of state budgets are made up of federal dollars. That would be inaccurate. What I said is 60 to 65% of state budgets, generally speaking, are controlled in one way or another by federal control. So a lot of times they will control you through their regulatory authority and cause the state to have to act in certain ways based on federal regulation. So I just want to clarify that. Do I think the states are enablers? Absolutely. Would I be personally in favor of the states not taking those dollars? Personally, absolutely. However, if we want to stop the states from enabling the federal government, the founders actually gave us a way, and it was Article 5. And they said that they expected that the federal government would get out of control and operate outside its boundaries. And the ultimate act of federalism provided by the founders in the United States Constitution under Article 5 is the calling of a convention. So my answer is yes, I absolutely think the state should act, and this is the methodology that the founders gave us to act against an out-of-control federal government.
Again, I disagree a little bit on your premise, but I think the states, as being enablers, need to be corrected first, because you've got to correct the problem before you correct the solution. You mentioned going against the state constitution. So here you are as a member of the COS advocating for less federal control, more state control. But now you're saying, let's go with the federal control on this because we want this COS to pass. So we think your Constitution violates the federal Constitution. Nowhere in Article 5 does it dictate to states how they will pass an Article 5 resolution. It says it's delegated up to the legislature. The legislature passes laws. In order for that statute or for that constitutional amendment to pass, or that provision in our Constitution under Article 2, it had to come through the legislature. So the legislature did play a role. If this legislature wants to reverse that, there's a process for that. We can do that. That has never been tried. So it's for someone advocating federal government's the boogeyman and the state government is the savior, why are we not trying at the state level first and then saying, oops, in this case, we're going to side with the federal government because they have all the power?
With all due respect, Senator Hildebrand, you are mischaracterizing my position. I'm not advocating the states against the federal government or the federal government against the states. I'm advocating for the United States Constitution. I stand here and say we should live by, and we should support, and we should utilize the tools given to us by the United States Constitution. As a constitutional attorney, I have a fundamental understanding of the United States Constitution, both its boundaries and limitations and its powers. Within the United States Constitution is the Supremacy Clause. Well settled. There's no court that disagrees with this. There's no state legislature that disagrees with this. In fact, it would be constitutional malpractice for an attorney to disagree with this, which is that the United States Constitution is supreme as to the matters it speaks upon. And in this case, it sets forth the way that an Article 5 convention works. So you and I are in fundamental disagreement on that, and maybe that'll be litigated at some point, but I can tell you the courts have spoken on this. I read the case. I could go through the list of cases that speak to this very issue, and there are cases dating back, I believe, into the 1800s, as late as the 1980s. And so we just have a disagreement on that point of law.
Let's address your court case of Selman versus Richard. That wasn't a victory, right?
I'm not familiar with the case that you're citing.
It's the one in Missouri that you cited last night, that it was a victory for the COS.
It was a victory. It did not allow the state to change the rules. There was a litigant who litigated saying that we had to follow state rules in regard to that case, or in regard to Calzone. You're talking about the Calzone case?
Correct. That was dismissed on a technicality because Calzone didn't have.
That's correct. So that is a victory. I mean, obviously, the way a litigation works is if a case is dismissed, the person who didn't have the case dismissed is victorious.
Okay, so if the case would have been vice versa and it was dismissed, you would call that a victory as well, because the judge ruled that the person didn't have standing to bring that case. That is why it was dismissed, not on the grounds or the terms of the case, but on the person did not have standing. To me, that's not a victory. That's a technicality.
I understand that you're saying that, Senator, but as a lawyer, a licensed lawyer since 1988. I'm just going to tell you on a legal basis, you're not correct.
Okay. Well, you count victories a lot different than I do, so thank you.
Are there any other questions? Yes, Senator Dietrich. I saw her first.
Thank you. I just wanted to clarify something. You said you talk fast.
I'm sorry, Senator.
That's okay.
I apologize.
That's okay. So I wrote down when you were talking about the question, when you were answering Senator Hildebrand about the Supreme Court, you said do away with institutions. And you were talking about the Commerce Clause. What institutions are you talking about?
Sure. So specifically, there are multiple agencies, administrative agencies of the federal government that have been set up under the auspices of Commerce Clause authority, greatly expanded authority granted to the federal government by the United States Supreme Court under a line of cases beginning with Wickard v. Filburn. I believe that was 1931. And these agencies have no constitutional basis for their existence according to the Constitution. I'll give you a very specific example, Senator. The Department of Education is not authorized under the Constitution, and I've argued this with a lot of people, and all we have to do is look back to Thomas Jefferson. Jefferson has a series of letters between he and one of his closest friends, William Henry Lee. Jefferson was a great proponent of public education, perhaps the greatest among the founding fathers. He believed we needed an educated electorate. When he was founding University of Virginia, Henry Lee suggested that he get federal money for University of Virginia. And Jefferson wrote back and said, well, that's unconstitutional. And essentially, we would need an education amendment before we could do that. Of course, he was there among the founders. There has never been an education amendment. The reason that we have a Department of Education, or that we are allowed to, that authority exists, is because the Supreme Court has broadly interpreted the Commerce Clause to allow that.
So besides education, may I ask what other things or what are other agencies you believe have been expanded?
Sure. So we can look at a lot of the alphabet soup of agencies. So for example, there's no constitutional authority for the Environmental Protection Agency. And the states all do a fantastic job of that. In my travels across the country, I've been in 48 state legislatures. Federal government doesn't have authority for that. The federal government doesn't have authority over agriculture within state lines. So that you could go through, and it's roughly, I'm roughing this because it's hard to say exactly, but roughly 40% of federal agencies exist under what is called Commerce Clause authority. And that's the authority that would be cited when those agencies were created.
May I ask one more follow-up? I'm sorry, I don't mean to take too much time here. So if you were to dissolve those agencies because they don't have the constitutional right to exist, do you not see some disruption to our everyday lives and the way we regulate agriculture, education, the environment? Or is that something that you don't want us to do? You don't want us to regulate?
No, I do believe we need to regulate to some extent those things, but I'm a big fan of state-based regulation, that people who understand agriculture in Kansas regulate agriculture in Kansas, as opposed to that coming out of the Department of Agriculture. Much of our tax base that goes, for example, for agriculture, that goes to Washington, D.C., and then the money comes back to Kansas after it goes to Washington, D.C. I believe that money should stay in Kansas, should be decided and regulated by Kansas. So would it create some disruption? The answer would be it depends on how we did it. Most of these things, I believe, what a convention would do is they would have a time period before those agencies are phased out. They would have a twilight period. I don't think anybody who's at convention would just say we should just shut down that agency tomorrow and create chaos. Because I agree with you, these agencies are deeply embedded into American life, and it would take time for the states to take over these functions and the funds that go with those functions.
Thank you.
Senator Ware.
Now I'll have the mic. You know, the idea of term limits, not too bad. Balanced budget might be painful, but a reasonable thing to do. The third point, though, that you have about the government just being too big is where I have some concerns. For instance, it sounds to me, in my reading about Convention of States, is that we don't really know how we would choose the delegates that would be making these incredibly, monumentally huge, never almost been decided before, 1776, ideas and putting them in place. We don't know how those delegates would be chosen. We really aren't sure at all because nothing is settled about what procedure they would take. I mean, we don't know if these would be elected folks, and we're not sure how they would be managing it. And there is so much at stake here that we could completely upend. I mean, you say that we're limiting, but saying too big a government really means anything, right? I mean, it does. We could lose the Bill of Rights. We could certainly lose any of the programs that millions of Americans depend on, Medicare, Social Security, you know, any number of things as every aspect of our lives. So how can, I'm terribly uncomfortable with just saying, yeah, okay, that we can go on, well, I believe it would be like this, or I believe it would be like that. That's way too vague, seems to me.
A question, Senator? That was a commentary.
What would
I appreciate
be,
your comments.
right, well, what is your response to that? Am I right?
No, fundamentally, with all due respect, Senator, at every level of what you said, you're incorrect. I mean, you did express opinions, and I appreciate your opinions. Those opinions are expressed, I would argue, out of two places. One is fear, and one is lack of knowledge. And my request would be that you read the law of Article 5, because everything you talked about does exist. And we have a long history in this country. There's an entire treatise been written about it. We have an over 200-page legislative compendium on our website that contains answers to all the questions that you ask. So I don't mean it in any way as an insult on lack of knowledge. There's a lot of things I don't know about because I haven't read about them enough to know. And so, for example, let's talk about how you choose the delegates. I'll get into some of the specifics. We don't know in the sense because that's called federalism. And all of us live in and believe in and actually swear an oath to a constitution that enforces a system of federalism. Kansas, the Kansas legislature, you here in the legislature would decide how you choose your delegates. And that doesn't scare me from my perspective. I think that's fantastic. I want the states to exercise all the power that they have under the United States Constitution. So we don't know because the Constitution leaves that to the states. When those delegates go to convention, we do know the limits on their power. We know because 34 states are required to pass the same resolution and agree in advance what that resolution says, what the discussion will be like at convention. Generally speaking, we do know what the rules will be at convention. We don't know exactly, and I'll definitely give you that. However, in American history, and this is something people are generally very confused about, they think that there's never been a convention, we don't know anything about conventions. There's a long history of conventions across American history. 11 conventions before 1787, over 30 since the 1787 Constitutional Convention. They've operated under almost an identical set of rules. The rules are summarized in here. You can read them if you like. The courts have ruled on this issue, on issues around Article 5, over 40 times. Again, you could read that all in here. And they've always said that the rules of a convention are based in precedent and history. We have a long precedent in history. In American history, for example, it has always been one state, one vote throughout American history in every convention. There was one convention where they did try to change that. That's the Washington Peace Convention, just prior to the Civil War. And the states did vote. And the states with a bigger population, of course, wanted more power in that convention, and they voted one state, one vote to keep it one state, one vote. It is also called a convention of states for a reason. We know it's one state, one vote. These are sovereign states participating. It's not a convention of delegates or populations. You mentioned the Bill of Rights. Important to understand the Bill of Rights cannot come under attack in this convention. If you read the plain language of the application itself, it would not apply to the Bill of Rights. We brought in legal scholars from across the spectrum, dozens of legal scholars, to make sure that that could not be done. So that's not Mark Meckler's opinion. You could look at our legal board of reference, Robbie George from Princeton, Randy Barnett from Georgetown, John Eastman from Chapman, Professor Rob Nadelson, the premier expert on Article 5 in the country. These are people who've spent their entire lives doing nothing but studying the Constitution, and they disagree with your conclusion that these people could just look at anything they want. And I would encourage you, get a copy of Law of Article 5, and I'd be happy to continue this discussion.
Mr. Mark, thank you. Are there any other questions for the proponents? We do appreciate that question. Thank you very much.
The committee.
We do have the opponents. I will say that we do have written proponents. We have, I think this is a record for, while I've been here, 22 proponents. And they are in your packets, so take a look at those. So we'll go to the opponents. and John Axtell, Kansas Campaign for Liberty. John, welcome to committee.
Honorable Chairman Alley and members of the Senate Federal and State Affairs Committee, I'm John Axtell. I'm from Wichita, and I'm a volunteer coordinator with Kansas Campaign for Liberty. The Constitution is already very powerfully and clearly written to truly limit the federal government, and if it were enforced, it would certainly do that job. This resolution assumes, on the other hand, that there's a problem with the words in the current Constitution, that they're deficient in some way. But that assertion or assumption could not be further from the truth. Let's look at the problem, which is the fact that we don't enforce the Constitution, and let's look at an example of that. Let's look at our huge debt, which is caused by our fiat currency. It's caused by our fiat currency in two ways. One is cheap money encourages borrowing by lowering interest rates, and cheap money also causes inflation, meaning you can't buy as much stuff in the future as you can spending that currency today. We all know about that. Our fiat currency causes debt, and it is a currency that's not backed by gold or silver, and that's in brazen violation of Article 1, Section 10 of the U.S. Constitution, which states that nothing but gold and silver shall be legal tender. We allow fiat currency to exist. We allow this violation of the Constitution, and therefore we have our debt. It's as simple as that. And this is just one example of the many ways in which the Constitution is not enforced or followed with serious consequence. Next, implicit in this resolution is the idea that once these resolutions are passed, the desired amendments are ratified and so on, we've had a convention and everything, that we can all relax and sit back, and these words, the new words, will somehow enforce themselves. You know, I'm a conservative and I make fun of gun-free signs because gun-free signs are impotent at enforcing themselves. Words and symbols don't do that. If we want words in the Constitution that truly limit the power of federal government, it's our job to enforce those. There is no paid professional law enforcement team like there is for all the statutes and ordinances and even the rules created by bureaucrats. Those are enforced by paid professionals. We are the people that enforce the provisions that truly limit our federal government. And if we don't do that job, it doesn't get done. No words exist with that power to self-enforce. Third, if we look at the political landscape in this country, there's no chance of gathering together 38 states in support of decreasing the power of the federal government. And on the other hand, Kansas is arguably one of the 5 or 10 most conservative states in this country. So 38 or even more states, all less conservative, could easily join together and totally ignore the will of the people in this state, having a constitutional convention and ratifying amendments that could destroy our liberties and certainly would leave out Kansas. Lastly, in January, legislators solemnly swore to support the Kansas Constitution, finishing their oath by saying, "So help me God." Yet leaders in the effort to pass this resolution, including some of the legislators, had planned to pass rules allowing, quote unquote, passage of this resolution with a simple majority, in clear and direct violation of Article 2, Section 13 of the Kansas Constitution, which legislators swore to support and which requires a 2/3 supermajority. Now, I hear proponents complaining about the Supreme Court rulings as rogue or as not really acknowledging or respecting the Constitution. And yet they cite court rulings from that very same Supreme Court in justifying the opinion delivered by the Attorney General, which I have here. And I think the most important thing to know about this opinion is that it was written with the question in mind of this: will the federal government, which is the problem, allow a violation of the will of the people of Kansas, which they are not the problem, in order to fix the federal government, which is the problem? And whether he meant to or not, the Attorney General gave revealing testimony to the fact that this is not a matter of empowering the state of Kansas and bringing down the U.S. federal government. This is something exactly the opposite when he said that this process, and this is a direct quote, cannot be constrained by the people of Kansas, end quote. This process cannot be constrained by the people of Kansas. These leaders, these legislators swore under God to support the Kansas Constitution, and yet they plan to violate their solemn oath, giving us proof that this convention will not be governed by rules, procedures, or principles. Words need to be added to the Constitution when the words that are there are wrong, such as regarding slavery, regarding the lack of women's suffrage, 18-year-olds in the 1970s going off to war, being conscripted into war, and not being able to vote about it. Those are places where words need to be changed. But when the words themselves suffice, if enforced, suffice to constrain the federal government as desired by the proponents and by myself, when the words exist and they suffice to do that job, there is no need for changing those words. There is a need to enforce the Constitution. I urge you to vote against SCR 1611, and I stand for questions.
Thank you, John. Are there questions? Senator Faust-Goodell.
Thank you, sir. Thank you, Mr. Chairman. And I'm not sure if this is totally directed to everything, but I'm serious. I felt I was in Congress listening to you. I felt like we were in a higher supreme building or committee. So you mentioned that we here in Kansas legislators, we swear in and take our oath, but we usually do that at the beginning of our four-year session. Do you think that we should be required to do that oath at the beginning prior to each legislative session or not? Or do you have an opinion?
Well, that's a good question. I believe that your oath to fidelity to the Constitution and to the Kansas Constitution is like, if I may, it's like prayer, daily. Not that you should have to publicly recite it, but I think that's something to meditate on, right? On a daily basis. And certainly to contemplate whether you measure your oath to the Constitution and what you're doing here against the Constitution, right? Okay, so that's a daily thing to me. I don't know how to say it any better, and I hope that answered your question, but thank you, Senator.
Yes. Senator Hildebrand.
Thank you, Mr. Chairman, and thank you, John, for your testimony. Regardless if you're for Article 5 or Convention of States or not, I'd say everybody that's part of the Article 5 movement, Convention of States, are patriots, and they genuinely want a solution. They see that as a solution. That is a solution that's brought to them. That's why it's so popular. What, if that is not the solution, what is the solution?
Thank you for bringing that question, because I have a great deal of respect for the patriotism of the proponents And so I wanted to be clear on that. This is not a debate with their personal character or anything like that. But the solution to this problem is local and state activation right here in Kansas that would empower our local teams and our state to act in ways that would actually be more constitutional, okay? Such as talking about the way funding is received from the federal government and then spent, for example. But we need to organize. We need to draw people together on the basis of constitutional principles to do things like, well, Campaign for Liberty in Kansas here is working to pass the Kansas Legal Tender Act, which I've talked about the fiat currency already. And the Kansas Legal Tender Act would restore gold and silver to the proper status, the constitutionally required status, by the way, of legal tender. And gold and silver have the special properties, like I've talked about, of being real money, and they're very, very important in empowering the poor and the lower middle class once again. They've been left behind in our fiat currency world, and so on. At the federal level, we're doing other things in Campaign for Liberty, but the state group wants to also end the highest sales tax on food, or one of the highest sales taxes on food in the country. We have several programs like that and things that we'd love to do, and I can go into a great deal of detail about the kind of organized effort we're trying to accomplish. But I think I may have answered your question. I'm not sure. Did that help?
I just wanted to hear your perspective on what it was, so thank you.
Yeah, we do need to organize locally.
Any other questions? Thank you, John, for coming today. Appreciate your testimony.
Appreciate it.
The next two are remote. The first one we have is Judy Collier from the Citizens Against Article 5. And Judy, are you online? Judy?
I'm here. Can you hear me?
We can.
Can you see me?
Yes, we got you.
Whoops.
Had you. There we
I
go.
can't work. You can hear me, right? I can't work the video. Can you hear me?
Yes.
Okay. Oh, there I am. Thank you very much for inviting me here with testimony. I don't think you have to be a constitutional attorney to understand the Constitution. And this is just aside from my prepared, what I was going to say. But Article 5 gives Congress a lot of power. What they give to the state legislatures is the power to ask Congress for a convention. It is very clear, which should mean that the state can decide how to ask Congress by what vote. But the legislatures do not propose amendments. They do not call the convention. Congress does that. And by Article 1, Section 8, the necessary and proper clause at the end, Congress sets the rules for the convention. And that includes delegate selection and how it's done. So the states don't necessarily get to do even that. And then as far as the ratification process goes, Congress decides which ratification process and if the states' legislatures do that. But I wanted to say that if you think you'll be voting on an application for Congress to call a limited convention, you're mistaken. Proponents don't believe their own false narrative, which is that 34 states need to pass the same or similar applications to trigger a convention, and that the resulting convention would be limited to the subject of the applications so that a runaway convention would be prevented. That just isn't true. Nothing in Article 5 says anything like that. So the scholars of the convention lobby, including Rob Nadelson, what they're doing is they're doing these aggregation studies, and they are using centuries-old applications to aggregate with these subjects, which are the BAIT, the Balanced Budget Amendment, the term limits, limiting the federal government. They are looking for, I call them wild card applications. They're using old applications centuries-old applications that apply to like the direct election of senators, which came out of Oregon in 1901, 1861 applications to avert the Civil War. New York had a application to get a Bill of Rights in 1789. And then there's these unlimited applications on no subject at all, just asking for a convention. These are being aggregated by scholars. Congress does the aggregating, but these are what they're going to go to Congress with to tell them that we have enough applications right now to call a convention. Strategists are testing the waters to see if they can get away right now, and with Georgia being their 34th state, to pass an application. They have a BBA application there, and they've passed right now in 27 states, but they're skipping the rest of them because they have 6, I call them wild card states, to add, like from the Civil War. The American Constitution Convention, which has board members that have backgrounds in the Convention of States and the BBA, their scholars are mixing and matching things and coming out with 37 applications already instead of the 34. And that includes Convention of States applications. US term limits has 4 applications that they got passed by states in the last 5 years, yet their website reveals that they're counting 28 states because they include all of the applications that the Convention of States has passed because they have term limits in it. And then they add 13 wildcard states to that, and they are from the Civil War, et cetera. And so why are the proponents playing with the numbers like this? Well, we don't have to guess because their strategists have written about it. The lobbying groups have plateaued, they say. The legislators have had their fill of this issue. More states are likely to rescind applications, and their scholars are concerned that a limited convention, if called by Congress, might be declared unconstitutional by an originalist Supreme Court. They say timing is everything. The public is outraged at the corruption and dysfunction in DC. And they say that proponents need to grab whatever applications they have now, quote, a bird in the hand, and demand that Congress call a convention right now. And if that fails, they say, they'll recruit state attorney generals to sue Congress for an unlimited convention. Yes, an unlimited convention. And why not? Because there's no such thing as a limited convention under Article 5 or in the US Constitution. They can use our talking points from the opponents to go to court to do this because we're all now saying the same thing except the lobbyists who go to the legislatures because they want your vote. Congress can aggregate applications however they wish, and delegates to an Article 5 convention cannot be limited by the subject of the application, by delegate laws, or anything. They have more power than state legislators. So they could dissolve state legislatures and Congress. It's apparent that state legislatures are being a sideshow to build momentum so they can convince Congress and the media that the people are demanding a convention when they have no idea the dangers. And that's the way those polls work. They ask about term limits, they ask about debate, the subjects, sure, people want them, but they don't know anything about the dangers of an Article 5 convention, and that cannot be done in a 3-minute robocall. This is a public relations campaign. The applications are already in. They don't need stacks of applications. Each state counts only once toward the 34. Kansas is already in. You already have 4 applications there, and they're being counted right now. The ones that I forgot what, I think there may be one on the direct election senators. Definitely your BBA is being aggregated by proponents with things from the Civil War and the Bill of Rights. The easiest way to get a new constitution, short of a hostile takeover, is through an Article 5 convention. It was not meant to rein in an out-of-control government. It was meant for defects in the Constitution. This is a convention that Madison, Hamilton, and John Jay warned about, this second convention, an Article 5 convention. They do not believe their own talking points. Why should we? Please vote no on SCR 1611.
Thank you, Judy. Are there any questions? Seeing none, thank you very much for being here today. We appreciate that. Our next opponent is Mr. William Rich. And you're remote. Mr. Rich, are you online?
I'm here. Can you hear me?
We can.
Wonderful.
Proceed.
Mr. Chairman, members of the committee, my name is Bill Rich, and I'm an emeritus professor of constitutional law at Washburn University. This morning, I want to briefly emphasize 2 points to supplement my written testimony. First, I find it difficult to understand why people would believe that now is the time to hold a constitutional convention aimed at undermining the role of the national government. After a year of the COVID pandemic, we all understand the impossibility of predicting challenges we may face in the century to come. Can we predict what the future holds in terms of protection from cyber terrorism or coping with dramatic climate change? What will it take to compete with China in the world of international finance? And what problems will we face as a nation that we cannot even imagine today? The great strength of the United States Constitution has been its open texture, and here I disagree with some of what was said previously. This permits change over time to meet problems that we could not have imagined in 1787. And I view the Commerce Clause as a perfect example of this. For example, the Commerce Clause is what gave authority to the national government to address civil rights. The Civil Rights Act of 1964 was based upon the Commerce Clause authority of Congress. Do we want to say that the national government should not be allowed to address civil rights in this nation? That's the kind of topic that would have to be addressed in the Constitutional Convention that's being discussed. The resolution before this committee was simply undermine the strength of our national government. And my second point is procedural. It relates to the 2/3 vote issue that others have already talked about. And as noted, current rules require a 2/3 vote in order to adopt this resolution. Last year, however, the Kansas Attorney General issued an opinion that Article 5 of the U.S. Constitution limits enforcement of the Kansas constitutional provision that states recommendations of constitutional amendments or conventions must have a 2/3 support from the legislature. While I strongly disagree with the Attorney General's constitutional analysis, which in my view has been thoroughly discredited by one of the nation's top constitutional scholars, Professor David Super, this morning I want to emphasize a more fundamental point focused on what the Attorney General's opinion actually said. The Attorney General conceded that the Kansas legislature may adopt a 2/3 vote requirement before advancing a constitutional convention resolution. In other words, you remain free to impose that requirement on yourselves. A simple majority vote would remain contrary to the text of the Kansas Constitution. Technical questions about enforcing that provision do not change your moral obligation to uphold provisions of the Kansas Constitution, which was, if anything, strengthened by the opinion of the Attorney General when he affirmed the validity of a self-imposed 2/3 vote requirement. I close by encouraging all of you to remain faithful to your oath of office when you establish the procedure for considering this resolution, if that issue should arise. Thank you again for the opportunity to testify this morning. I'll remain available for questions if you have them.
Thank you, Mr. Rich. Are there any questions? Seeing none, thank you very much for your testimony this morning.
You're very welcome.
I want to call your attention to the, I think we have 5 people that have sent in written opposition, and there was no neutral testimony given. So if there's nothing more to be brought before the committee, this committee is adjourned. Thank you very much for your testimony.